The moment everything changed, something just snapped in the system. For decades, concealed carry in America was buried under layers of red tape, permit delays, subjective good cause standards, and judges who quietly sided with bureaucrats over the Constitution. But today, that's over. In a historic 6-3 Supreme Court ruling, the justices didn't just overturn a single gun control law, they struck at the entire foundation of how states restrict your right to carry a firearm. This decision wasn't a tweak, it was a revolution, and it's already shaking courtrooms, collapsing state laws, and triggering panic among anti-gun politicians. You want to know what just happened and how it affects you? Just the raw truth about the legal battles shaping your future. Stay ahead of the fight, like this video, and subscribe now. Today, we break down exactly what this 6-3 ruling says, why it's far more powerful than you've been told, how states are reacting or resisting, and what this means for you as a law-abiding gun owner. Let's get into it. Chapter 1. The 6-3 ruling that rocked the court. The decision came down like a hammer. 6 justices in favor, 3 dissenting. But what made this ruling historic wasn't just the numbers, it was the message. Why this vote matters. 6-3 shows a strong constitutional majority, not a narrow or shaky one. It signals to lower courts, we mean business. Follow the Constitution. It puts anti-gun states on immediate notice. Your laws will be tested. The case at hand challenged a state's permit system, a law that required citizens to beg for permission before carrying a handgun in public. The court said no more. They ruled that the right to bear arms doesn't end at your front door. It doesn't depend on whether a local sheriff likes you, and it definitely doesn't require good cause or a waiting period. This decision resets the rules. If the Second Amendment protects it, you don't need permission, period. Chapter 2. The Permit Trap. How we got here. To understand why this matters, we need to rewind 100 years. Because permit laws didn't start as public safety efforts. They started as tools of discrimination and control. How it evolved. After the Civil War, Southern states passed black codes to disarm freed slaves. In 1911, New York passed the Sullivan Act, requiring permits to carry. Its real goal, disarm immigrants and the working class. Throughout the 1900s, urban states copied the model. High fees, subjective standards, and impossible rules. Courts refused to intervene, treating the Second Amendment as a second-class right. By the early 2000s, states were divided between may-issue states, where permits were often denied for no reason, shall-issue states better, but still full of delays, costs, and restrictions. This 6-3 ruling calls that entire system into question, because rights aren't rewards, they're guarantees. Chapter 3. The Bruen Effect, a legal earthquake. This ruling didn't come from nowhere. It builds directly on the landmark Bruen case from 2022. In Bruen, the court said no more balancing tests. If a gun law isn't rooted in text, history, and tradition, it's unconstitutional. What Bruen changed, courts can't just say, this law feels reasonable. States can't hide behind the words public safety. Judges must ask, would this law have made sense in 1791 or 1868? The 6-3 ruling is Bruen's younger, more aggressive cousin. It applies that historical test with full force to permit systems and possibly to bans, waiting periods, and more. It tells judges, stop inventing rules, start honoring the Constitution. Chapter 4. Ripple effects across the nation. Within hours of the decision, states across the country were in crisis mode. Some scrambled to rewrite their laws, others dug in their heels, preparing for legal warfare. Immediate reactions. California tried to rewrite its carry law, but expanded sensitive places to cover entire cities. New York passed the Concealed Carry Improvement Act, which critics say made things even worse. New Jersey doubled down on restrictions and added insurance mandates. Texas, Florida, and Georgia leaned into constitutional carry, citing the ruling as support. Meanwhile, lawsuits exploded across all circuits. Gun rights groups like GOA, FPC, and SAF flooded the courts, citing the ruling as fresh ammo against outdated restrictions. The result? A legal earthquake with aftershocks still coming. Chapter 5. States are fighting back, but losing ground. If you thought anti-gun states would surrender, think again. They're fighting tooth and nail to keep control, but their tactics are showing cracks. Tactics being used: expanding sensitive places to absurd levels, airports, parks, churches, and parking lots. Requiring liability insurance before you can carry. It imposes excessive training hours, high fees, and endless paperwork. Creating emergency laws to stall new applications or delay rulings. But here's the problem for them. None of these ideas has any historical precedent. There were no sensitive zones in colonial America. The founders didn't carry insurance to bear arms. They didn't get permission slips from British governors. That's why these new laws are already under fire in court. And this time, the courts can't use old excuses to uphold them. The message is simple. You cannot ban a right just because you fear it. Chapter 6. The new legal standard text. History. Tradition. This Supreme Court ruling didn't just strike down one law. It redefined how all Second Amendment cases must be judged from now on. It created a bright line test that cuts through politics, fear, and manipulation. Here's how the new framework works. Text. The plain meaning of the Second Amendment comes first. History. Judges must look at laws from 1791 or 1868, not modern fears. Tradition. If there's no historical equivalent, the modern law cannot stand. No balancing. Public safety arguments no longer override your rights. Precedent reset. Courts must now follow this method, no shortcuts. This new standard wipes away decades of judicial activism. It reminds judges their job is to protect rights, not invent exceptions. And for gun owners, this means dozens of outdated laws are now living on borrowed time. The Constitution is no longer up for reinterpretation, it's being restored. Chapter 7. Everyday impact on gun owners. Big rulings can feel distant until they hit your daily life. This 6-3 decision isn't just about courtrooms. It's about your carry permit, your travel, your peace of mind. Here's what changes immediately. Permits. Good cause and may issue systems are falling fast. Traveling. More states may be forced to honor out-of-state permits soon. Traffic stops. Carrying legally is now presumed lawful, not suspicious. Shall issue states. Even these may evolve into full constitutional carry. Self-defense confidence. You no longer carry. Hoping the law is on your side, it is. This ruling brings power back to the people. Millions who once feared legal traps now stand on solid ground. You're not applying for a right anymore. You're exercising it freely and lawfully. And the message is clear. The right to bear arms is no longer negotiable. Chapter 8. The Political Firestorm. No ruling this powerful comes without backlash, and this one has unleashed political chaos in Washington, state capitals, and media networks coast to coast. Key developments since the decision: Senators Schumer, Murphy, and Feinstein are proposing new restrictions. Blue states are trying to redefine carry zones, making almost everything off limits. Insurance mandates and taxes on gun owners are being floated as workarounds. Red states are pushing new constitutional carry laws to follow the court. The 2026 midterms are already shaping up to be a battle over this ruling. This is no longer just about law. It's about ideology, elections, and control. And that means the fight is far from over. Gun owners have the law on their side, but they'll need to defend it politically too. Because when freedom wins around, the system doesn't surrender, it regroups. Chapter 9. The Domino Effect. What comes next? The ruling was about permits, but its ripple effect is just beginning. Every major gun control law is now vulnerable, and lawsuits are coming fast. Here's what's already under legal attack. Assault weapons, bans already falling in multiple circuits. Magazine restrictions being struck down using Bruen-style arguments. Waiting periods lacking any historical precedent. Sensitive place laws, cities trying to ban carry everywhere are losing. Training mandates and fees now challenged as unconstitutional burdens. This decision didn't end the fight. It opened a legal floodgate. Gun owners are finally playing offense, not just defense. And this ruling is the battering ram breaking down every unconstitutional wall. Chapter 10. A turning point in American history. Every generation faces a moment when the meaning of the Constitution is tested. For the Second Amendment, this 6-3 ruling may be that moment. Why this ruling is historically massive. It doesn't balance your rights, it restores them. It says gun rights are equal to speech, religion, voting, and more. It challenges a century of laws built on fear, not freedom. It sends a message to every judge: start defending liberty again. It reminds politicians the Constitution isn't a suggestion, it's binding. This isn't just a win for gun owners, it's a victory for everyone who believes rights don't need permission slips. It's a return to first principles, to the founder's vision, and it's only the beginning. Your rights, your voice, your future. So here's where we stand. The Supreme Court just reset the rules for gun ownership in America. States are panicking, resisting, or rewriting their laws. And gun owners, you're finally standing on solid constitutional ground. But this isn't the end of the story. It's just the first battle in a much longer war. Although the court has made the law clear, politicians are already plotting their next move. That's why you need to stay sharp, stay informed, and stay in the fight. Just the raw truth about the legal battles shaping your future. Like this video, subscribe, and turn on notifications so you don't miss a single update. Share this with a fellow gun owner who deserves to know the truth. Because the more we educate, the harder it becomes for anyone, court, Congress, or governor, to steal your rights in the dark. Stay free, stay armed, stay ahead.